Hello, and thank you for joining me. Whether you're watching this video live or coming back and watching the recording, I appreciate you joining me to learn about this topic today. My name is Erica Dotros. I am an attorney at Mullen PC. We are a boutique law firm with offices just outside of Dallas and Philadelphia. Our practice focuses on franchise law primarily, but we offer general commercial law services as well. So we often work in that area where franchising intersects with another area of law. And that's what we're going to talk about here today is one of those particular areas when commercial lease agreements intersect with franchises. The lease agreements often have common provisions that, when applied to a franchise relationship, may need to be further negotiated or modified in order to account for the common terms in a franchise agreement and the unique aspects of that relationship. So that's what we're going to go over today are some of those provisions that you may see in a lease agreement that may need special attention. What I hope that you'll get from this is if you're a franchisee, this should hopefully identify certain areas of your lease you should pay particular attention to. When you start working with a broker, it also gives you some areas that you can discuss with them that may need to be negotiated during the LOI phase before you get the full lease agreement to negotiate. For real estate agents and brokers, I hope this gives you some tools to better represent your franchisees, especially those components that may be better discussed at that LOI phase when you're talking about general business terms, especially things that may be a deal breaker for your client. This should also provide benefits to franchisors as well. Under franchise agreements, franchisors have the right to approve or disapprove the terms of a lease agreement. And there may be some provisions here that we discuss that can better protect the franchisor's brand and may end up being part of what a franchisor either requires to be included or requires to not be included in their lease agreements. It also should give some better tools to help guide franchisees during that leasing process. Before diving in, I'll also like to note that we do hope to provide these types of seminars in the future. So if you have any ideas on any topics that you would like to discuss or have us discuss with you, or any information that you would find helpful, please feel free to drop a comment, let us know. You can also email us at the same contact information that you received the invite for the seminar. Now, diving in, I'd like to first give a little bit of background on how the franchise agreement and lease agreement process works. The reason for this is that it does give you a little bit of context of when certain negotiations should take place and what leverage you may have depending on where you are in the process. So typically, under a franchise relationship, the franchisor is going to have the right first in executing the franchise agreement to establish what the site selection area is. Of course, this is with agreement with the franchisee because it is a term that is negotiated at the time before they sign the franchise agreement. This means that the franchisee will have an area where they must locate the franchise business. The franchisor will also generally, under the franchise agreement, have the right to approve or disapprove the site, and as well as approve or disapprove the terms of the lease. They may also have certain provisions that they require to be part of the lease agreement. They also often have what's called the lease rider or lease addendum that gives certain rights to the franchisor to come in, remove their trade dress, or assume the lease if the lease agreement or franchise agreement is terminated. Because of that, typically a franchise agreement is going to be negotiated and entered into prior to a lease being entered into, and most often prior to a site ever being identified or even the franchisee contacting the real estate broker. This means that when you get to the lease phase, you don't necessarily have the ability to rely on negotiating changes in the franchise agreement. You're most likely going to be bound by what is already there. As a franchisee, if you haven't signed your franchise agreement yet, this may give you some insight onto things you may want to discuss with your franchisor and some flexibility you may want to add in. I'll try to note those as we go along where there may be some room for negotiation there depending on the franchisor. But typically, most of your negotiated changes are going to occur at the lease agreement phase. In both a franchise agreement and a lease agreement, you have a party that has valuable property that it is essentially letting the franchisee tenant use. And their use of that property can either diminish the value of that asset, or it can increase the value of that asset. For a franchisor, you're lending out the intellectual property, the brand, the goodwill, the reputation. For the landlord, you're leasing out the real property, and depending on what you do with those things, it can really impact the value of that asset, which means that both of these parties are motivated to ensure that they have full control over what happens with that property. Unfortunately, that means that the franchisee tenant is often put in a position where they have both parties that have sole discretion on what they can require the franchisee tenant to do. And so this discussion will go into some of the areas where these two terms may conflict and how we can try to get them in line so that the franchisee can hopefully be put in a position where they can comply with both agreements. So diving in, the first one I want to talk about is the lease term. This is generally a pretty standard term that you're going to see in every agreement. The lease term is going to identify when your lease term begins and when it ends. So this is the time where you become a tenant until the time your lease terminates. Lease agreements typically will permit a tenant to come into the property and begin construction prior to what's called the rent commencement date. That's when rent actually starts. The rent commencement date is typically also the start of the term. So, for example, if you've agreed to a 10-year term, the 10 years doesn't necessarily start when you get the keys to the property. It starts at the time that rent's commencement date is. The reason why this is important in a franchise situation is that under the franchise agreement, you're also granted a franchise term. Typically, there's an initial term followed by 1 or 2 renewal periods, and those can vary depending on what industry you're in, what franchisor you have. So it's important to align these. One of the reasons why this is important is because the franchisor can limit the franchisee's ability to relocate. So if you have an expired term and now you're not allowed to continue in that place for whatever reason that may be, there may be some limitations on actually picking up and moving to a new location, in addition to all the fees and cost in getting that set up. Additionally, most franchise agreements are also going to have a non-compete clause, which means that once the franchise term is over, you'll not be able to operate a similar business in the location that you are currently operating, as well as certain radius around where you are, and then around other franchise locations as well. So that means that if your term is longer, so if, for example, if your franchise term is 7 years, but you sign a 10-year lease, those last 3 years, if you didn't renew your franchise agreement, you would not actually be permitted to use the space for that franchise business, but you would still be obligated to pay the fees under the lease. So we want to avoid that as best as possible. Where this can get a little tricky is that the rent commencement date is often not really known at the time that you enter into the lease agreement. It may say something like the earlier of so many days after you receive permits, after you've received delivery of the property, or you opening for business. So depending on when those things occur, your start date may be a little bit different than when your franchise agreement starts. Also, franchise agreements can either start on the effective date of your franchise agreement, so when you sign the agreement, or it can start when you open. Typically, if both start when you open, that makes it a lot easier and you're on the same path. A little bit of overlap can be okay because it can give you some time to actually clear out the premises. But generally, you want to make sure those are as aligned as possible. And so that really takes looking at the exact phrasing of both of those provisions to make sure that they're going to align as closely as possible. Another area is the delivery date. So this is the date that the landlord actually hands the property to the tenant. And usually once you've handed that off, there's a certain amount of time that the tenant has to complete construction. the important component here is that in many lease agreements, the landlord will give you an estimated date that they're expected to give you the property, but they aren't necessarily required to give it to you then. This could be because there's a tenant that is holding over. It could be that the landlord has certain work that they're going to be responsible for, and it may take them an unknown amount of time. And so there may not be a specific cap or any cap on how long the landlord can take before they give that property over. Unfortunately, under the franchise agreement, franchisees typically have a deadline to open. They're often required to enter into a lease agreement within a certain period after signing the franchise agreement. And then they're also usually required to open the franchise business within a certain period of time of either signing the franchise agreement or signing that lease. So it's important to account for how much time the franchisee has to open, how much time the franchisee needs to complete construction to do that, and ensure that there is a deadline in your lease that the landlord must provide you with that property before that date. Usually you want to have some type of consequence if they don't. A common one is the right to terminate. I will caution that with that could also mean that if you do end up terminating in order to get your property in time, you do now have to go find another property, negotiate that lease, and go through the same phase. So you do need to make sure that you're accounting for that. But typically, the termination can just be a deterrent to ensure that you're actually getting the property at that point. Another option is looking at possibly doing liquidated damages per day or rent reductions, so that if there is any penalty with the franchisor that isn't termination, you would maybe be able to cover your damages there. The next provision I'd like to discuss is permitted use. Under a lease agreement, you're typically going to be limited to specific things that you can use the property for. A permitted use clause typically says that the tenant will use the property for a certain purpose and for no other purpose. So, for example, if you were operating a fitness franchise, you may say that the tenant will use the premises solely for the operation of a fitness and gym facility and for no other purpose. There are some variations in how this provision can show up. In some cases, it will say for no other purpose. Others will say that you have other ancillary and related uses. And then some will limit this to offering these services under a specific trade name, or even say that you're allowed to offer these services, but so long as they don't violate any laws, any restrictive covenants, or prohibited uses. We'll save the trade name and prohibited uses for another discussion later in this presentation. But in terms of the permitted use, the important component here is that in most franchise agreements, the franchisor is going to have the right to require the franchisee to offer and sell all products and services it requires, and only the products and services it requires. But the franchisor often also has the right to change those services over time, which means that there can be changes to your menu items. There can be, or your services, depending on what type of franchise you're offering. So if your lease agreement is very specific in the types of things you're allowed to do, then you may end up being in a situation where you don't have the right to sell certain products that the franchisor in the future is requiring you to sell. So ways that you can address this is, one, giving yourself that flexibility of saying ancillary and related uses. If there are items that the franchisor is likely to add in the future, and this may be a discussion with the franchisor to determine what those may be, then you may want to build those into your description of the permitted use as well. Another option is to say that you can also offer any services or products that are offered by businesses operating under the same trade name as you. That way, if the brand in general changes, you have the right to match that. It is common to get some pushback from landlords on that, because landlords also like to, they will occasionally grant exclusive uses to certain tenants, which means that they will tell one tenant, you're the only person here that's allowed to sell this product, in order to ensure that they have protection in their ability to sell and be profitable in that location. So if your rights are too broad, then it makes it difficult for them to negotiate those in the future. And so they may want a provision there that says you can you can make these changes so long as it's not violating an exclusive use, which could still put you in a position where you're stuck in between these two agreements, but can at least get you a little bit closer to being able to comply with each. The next thing we'll talk about is trade names, which I alluded to under the permitted use. Many lease agreements will identify the trade name that you're operating under. And in many cases, will say that you are only allowed to operate under that trade name. This can be problematic in a couple of different situations. One is that the franchisor under the franchise agreement typically has the right to change its name, its signage in the future. This often happens if there's a merger, a sale, if there ends up being a claim of infringement, if the franchisor is newer and hasn't received that registration for their mark yet. So there could be reasons why the franchisor elects to change its name down the road, especially when you're looking at a 10-year franchise term, especially if there's multiple renewals after that term. So it is possible that the franchisor at some point will require you to change your name. And so you do need that flexibility to change. If it's left to the landlord's approval, that can sometimes be difficult, even if it's in his or her reasonable discretion, because there can be reasons why they might think another name isn't going to be as profitable. It's not as well known. It won't drive as much traffic. And so being able to operate under the trade name that you're entering into the lease under, but also any modified trade name in the event that the business is operating under this trade name change. So you can enter in that flexibility by tying it to the trade name that's being used by the system as a whole. Another area where this could be problematic for the franchisee is if the franchise agreement terminates, especially if it's a case of where the franchisee has asserted fraud or some type of other issues with the franchisor, where the franchisee is asking to terminate the franchise agreement. In those cases, the franchisee may still be bound by that non-compete provision, and if that's the case, they can't operate in this area without violating that. They also would not be able to continue using the trade name, which means that even if you're released from the non-compete based on the claims of fraud or not complying with the franchise law, then you still would not, without the landlord's permission, be able to change your trade name, even if you can use it for the same permitted use. And so that's where there can be some difficulty for a franchisee, where there needs to be flexibility to allow you to mitigate your damages as much as possible if you're having to exit that franchise agreement. So one option for how to modify that trade name clause is to ensure that it is able to adjust for adjustments in the system as a whole, and also that you're able to change your trade name if the franchise agreement terminates. Another area that has a lot of impact on franchise systems are prohibited uses. So we discussed earlier that with permitted uses, there may also be tenants that have what's called an exclusive use. This is where a tenant may be granted an exclusive use where the landlord says that from the date of their lease and onward, they won't enter into another lease agreement or permit anyone to offer the products that that tenant is selling. And how they define that can vary pretty dramatically. So if you're a tenant in this premises, there may be restrictions on what you can sell. In some cases, the prohibited uses could even contradict with your permitted use. So permitted use clauses will sometimes say that you can use the property for these reasons or for these uses, so long as it doesn't violate the prohibited use clause. And so even if it says you can operate a breakfast diner, if the prohibited uses section has a restriction on operating as a breakfast diner, that is a breakfast diner is kind of a little oxymoron there. But if you if the prohibited uses contradict that, usually the prohibited uses are going to control, which means that you can't actually operate for your permitted use. So paying very close attention to this is very important, because the landlord doesn't always pick up on those conflicts. And sometimes it depends on the phrasing of these as well. How you define something may impact whether or not it's going to conflict with your permitted use. For example, the prohibited use may say that a tenant can't operate in the shopping center for an entertainment venue. But the permitted use may be to operate a fitness facility. So whether that's considered entertainment, probably not, but depending on what you're doing there, if you're offering certain types of classes, that depending on who that other tenant is, it may conflict. So trying to keep a really open mind when you're reading the prohibited uses to see if there's any way that those definitions could be an issue where the other tenant, if they start seeing a drop in their sales, may point to you as being the reason. Usually the restrictions are going to be a little bit clearer in whether they conflict or not. The other component of that is that you also need to look at the prohibited uses in the sense of where your franchise system may go in the future. If there are certain products that right now are only a small component of what you're doing, and you're not violating a prohibited use because of that. For example, if part of what you're selling is ice cream, but your main products are other types of desserts, then if another tenant has a prohibited or exclusive use that no one will sell more than 20% of their gross sales with ice cream, then when you enter the lease, it may be that ice cream is only predicted to be 5% of your sales. But over time, there may be more changes, more additions. It may be a bigger deal over the course of that franchise term where those numbers may shift. And now you may end up crossing that threshold of your gross sales now exceeding whatever threshold that tenant has before it's considered a violation of their exclusive use. So trying to keep in mind what products and services you may have in the future and how your gross sales may change over time is vital when you're looking over those prohibited uses. The next provision we'll talk about is the delivery condition. There are a few reasons why this is important. One, it's going to be important to any tenant what condition the property is delivered to you in. That's definitely going to impact how much you're going to spend in order to get the property up to the point that you want it to be at, or that the city requires in order for you to open and operate. But it can also impact your budget depending on what was disclosed in the franchise disclosure document. So the franchise disclosure document in the section that's identified as item 7 discloses your estimated initial investment. This gives the breakdown of what a franchisee is predicted to spend in order to get open and operating, and to operate for the first usually 3 months, maybe more, until they're able to get until they start getting revenue in. Many franchisees, when they're seeking loans or getting approved for the franchise, or determining how much they're willing to spend on the franchise, are going to look at these numbers and base it off of what the franchisor has predicted they would sell, or that they would incur. One particularly important component is this does include the leasehold improvements, and what they assume in terms of the condition of the property can greatly impact what number they put in for that estimated initial investment. So if your franchisor in the footnotes of item 7, item 7 is typically a chart that includes the line item, the estimated range, and who that money is going to, followed by footnotes to explain where those numbers have come from. And in those footnotes, they may indicate what assumptions they made in determining how much your leasehold improvements were going to cost. So you may look at that and it could say, we're assuming you're going into a second generation space that already has ADA compliant bathrooms, that it has an operating HVAC system, and all the electrical and plumbing are in good working order. which means if you get a vanilla shell and you have to build all of that out, or if you get a property where it's not ADA compliant, or if the HVAC system is not operating, you now are incurring a significantly larger expense in order to get that property to the point that you're able to open and comply with both applicable law and your franchisor and landlord's requirements. And so if you have budgeted a certain amount and you have now obtained a loan based on that, or you've only set aside a certain amount of money because of that, and the landlord is delivering the property to you in a condition that is less than or includes more work for you than what item 7 assumed, your numbers are now off and you may have trouble staying within budget and being able to get to opening and have that flexibility to give yourself time to become profitable. So this is where delivery condition is very important, and looking at what your item 7 says in those footnotes. So once you start looking at spaces, it's important to look at that and let your brokers know, or if you're a broker, ask your franchisee for that document and look what's there so that you can best guide the franchisee tenant to understand whether a property is going to fit into that or not, so that everyone can be realistic about whether a property is going to match with their financial capacity, as well as whether something needs to be negotiated with the landlord. So for example, if the HVAC system is in either an unknown condition or not operating at its best capacity, then it may be an opportunity for you to negotiate for that to be delivered in good operating condition and possibly with a warranty for a certain period of time, like 6 months, a year. So it's important to look at that section to see what is it the franchisee needs to have in order to stay on budget. And the landlord, in some cases, you can negotiate these and you can put in these delivery conditions. But in some cases, they may not have the capacity or the desire to do that, but it would at least give you the opportunity to know a property is not suitable for you. A similar component to that is the tenant's work. So once the tenant takes possession of the property, they will perform their work to get the premises with the right improvements, FF&E, and all the trade dress the franchisor requires, and also anything that's needed to be done to make sure that it's in compliance with applicable law and any of the requirements that the landlord has. So all of this construction now puts the tenant in a position where they're balancing again between two parties that want to have control over what this final product looks like. The landlord often will have deadlines to provide site plans, and they'll usually have the ability to approve or disapprove those plans and any of the changes that are going to be made to the property. At the same time, the tenant's required to build out the property in order to comply with the franchisor's requirements. And so they may have to use certain products in order to match with the franchisor's trade dress, because every location is intended to look very similar, if not the same. So this puts the tenant in a difficult situation to balance these two things. If possible, if the franchisor has the ability to assist with this and the franchisee has this information, if the franchisee can attach a site plan for the property to the lease agreement, saying that it has the landlord's approval, that can help ensure that certain aspects of the build out are already approved before entering into the lease agreement, so that you're not running into an issue with that once the lease agreement's signed and everyone's bound to continue under that. If there are certain improvements that are required, certain products, window treatments, awnings, especially things that impact the exterior of the property, those things can also be listed out in an exhibit to get the landlord's approval before you enter into the binding agreement. In some cases, that's not possible. The franchisor may not have the ability to give you a site plan specific to your location yet. You may not have the base drawings needed in order to provide those, or it may be something where that's just still in development and just can't happen on the timeline that's required in order to sign the lease. In those cases, you can still give yourself some flexibility by allowing the tenant to make alterations that are required by the franchisor in order to comply with the franchise standards, so long as they don't negatively impact the structural components or building systems of the space. That's a pretty broad term, so the landlord may not want it quite that broad, but that's at least a starting point to try to get some flexibility so that you at least have the ability to comply with the franchisor's requirements, so long as you're not actually damaging the landlord's property or the value of that property. On a similar note, throughout the term of the lease, and throughout the term of the franchise agreement, the franchisor may require the tenant to make certain changes to the property over time. These vary pretty dramatically in how what limitations are imposed on the franchisor. The franchisor may have just a blanket right that at any point during the franchise agreement, that it can require the tenant to modify the property to comply with its current trade dress requirements, or to add equipment, add other fixtures and furnishings, otherwise, refurbish and remodel. In other cases, the franchisor may be limited. It may be up to a certain value, or only at certain periods of time. So it may be only at renewal or every 5 years, something along those lines. So what the franchisor requires can vary, and this is where it can be important to know what's in the franchise agreement as you're looking at the lease agreement, to see how much room you need to negotiate here, so that you're being as reasonable with the landlord as possible, but avoiding these conflicts. The lease agreement typically is going to allow the landlord to have the right to approve or disapprove any alterations that are done to the property. From a basic standpoint, this makes sense. It's the landlord's property, and when the tenant moves out, they are taking the property typically with all those improvements still there. And so if there are improvements done to the property that devalue the property or harder to release at the end of the term, then that can be something that the landlord wants to avoid and may want to have that right to approve or disapprove. Because of that, with both parties having this right of approval or disapproval, it's typically best to have some flexibility that the franchisor or franchisee can make certain alterations, so long as it doesn't impact the structure or the building systems of the shopping center. And the reason for that is that typically landlords are not going to negotiate on allowing you to impact the structure, because it impacts the building as a whole and can significantly impact the value of the building. And so that would be the most flexible provision, would be to allow you to make any alteration, so long as it didn't impact those areas. In some cases, landlords want a financial cap on that, where it's only alterations under a certain value. In which case, this is where knowing what's in your franchise agreement can be helpful. If the franchise agreement only allows a franchisor to require you to spend so much money in order to do these renovations, then that can be used as the cap to give you that flexibility. Same thing with frequency as well. If there's a limitation on the franchisor's frequency to do this, then that can also be used. Now, this is an area that if you haven't entered into your franchise agreement yet, there may be some room for negotiation with the franchisor on these components to ensure that any ability for the franchisor to require you to renovate is limited to the non-structural components, because landlords are not going to let you impact their structure unless it's very limited situations where they may agree to that. And then if you also are able to limit the cost of each of those, then that can give you the flexibility to give the landlord what it typically is going to require in order to get the alterations provision to a point that you can comply with both. The next provision that I'd like to discuss is hours of operation. Typically, the landlord wants to set certain hours that the tenants are required to operate. The reason for this is that the landlord wants the property to be used. It wants to attract people to the property. It doesn't want the places being vacant or not really being operated. And this helps with ensuring that the landlord keeps the value of their property. The the conflict here is that franchisors are typically permitted to set the hours of operation for their franchisees. So there may be certain hours that they're required to be open, certain hours that they're prohibited from being open, or even certain days. So, for example, it may be certain holidays you're not allowed to operate, certain days of the week. And so the franchisee tenant needs to be capable of adhering to the franchisor's hours. Now, the franchisor typically is going to have the right to change these over time. So adding these specific hours that are required at that time is typically not the best option to modify the lease, because they could change in the future. And we want to give flexibility to ensure that the franchisee tenant is able to do that. So typically, the best way to do this, if the landlord will agree to it, is to have the hours of operation to be in compliance with what the franchisor sets. In many cases, the landlord is a little bit flexible on this provision because it knows that the franchisor is receiving its pay based on the royalties, which are calculated based on gross sales. So the franchisor is not going to require you to be open 1 hour a week or some very low amount if they're now limiting their own income by doing so. So there can be some mutual trust there in ensuring that even if it's set by the franchisor, it will still require you to be open a sufficient amount of time to be generating a profit and bringing people to the premises. If that's not acceptable by the landlord, there are some options to state certain minimum hours, but to the extent that but to do more hours if the franchisor requires. Some of this is based on a discussion between the franchisee and the franchisor to see what hours can be acceptable to put into the lease, and ensure that you have their approval on that. In that case, that the landlord doesn't just allow you to be controlled by the franchisor's hours. If there are certain days that the franchise system typically does not operate by policy, it's important to go ahead and put into that provision that the tenant isn't required to operate on those days or times, whether that's a certain holiday, certain day of the week, or a certain time of the day. For example, if you're operating a breakfast restaurant and you're only going to be open from 6 a.m. to 2 p.m., you may want specific requirements that allow you to close after 2 p.m., whereas a typical business would probably still be open after that time. So this is the negative form, rather than affirmatively requiring certain hours, giving you that ability to specifically avoid being open during certain hours. So you always have the right to, in the future, if the franchisor decides to expand its model, for example, going back to that breakfast restaurant, if you're operating from 6 to 2, but now the franchisor wants to start offering dinner options and now has extended out the days, you would have that option to open during that time, but otherwise would not be required to operate. So that is also an option to see it more in the what hours are you not required to be there. Shifting focus a little bit, another provision that is common to see in lease agreements is the right for the landlord to relocate the tenant. So in these types of provisions, the tenant may be required to move from its current premises to another similar premises on the property if the landlord requires. Typically, the franchisor will cover certain costs for that. But the difficulty in this situation is that the franchisee is typically under the franchise agreement required to operate at the location that was approved by the franchisor. So if the franchisee relocates even to a different premises on the property, that could be a violation of the franchise agreement. It may also incur additional fees for the franchisee. For example, in many franchise agreements, the franchisor will impose a relocation fee in order to approve that new site and to facilitate all the paperwork that is required to acknowledge that transfer of the location. And so the franchisee can incur those additional fees that may not be accounted for within the the reimbursement that is typically included in those relocation provisions. So typically the best policy on this is to attempt to remove any option that the landlord has to relocate the tenant based on those restrictions in the franchise agreement. In many cases, landlords will agree to that and understand the restrictions that tenants are put under when they also have a franchisor. But if that's not the case, if you do have to leave this in, ensure that you do have the ability to condition that on the franchisor's approval, that any expenses that you're going to incur to the franchisor is also covered in any of those expenses that get reimbursed, along with the moving cost and cost to improve the property. And then also there are typically restrictions on the time period that you're allowed to close in between operating in those two locations. So it may say that what I typically see in a franchise agreement is that if you're relocating for a casualty loss, for example, a tornado, a fire, that you may have a certain period of time that you're permitted to close before reopening in a new location. But if it's for any other reason, so in this case, being relocated by the landlord, you have to open the day after you close. So there's no gap in between. You have to be building out the new property while you're still operating in the other. And so you're occupying both until that opening date at the new location. And so it is important to ensure that you know what is in that provision in your franchise agreement, so that if you are required to keep the relocation provision in your lease, you know what time frame you need to require from the landlord in order to comply with your franchise agreement. Another area that is particularly important for franchisees are the transfer provisions under your lease agreement. So your lease agreement will typically say that you're not permitted to transfer your lease or sublease except with the landlord's consent. There are a few different layers of circumstances where a tenant that's a franchisee may end up needing to transfer its lease. One is that the franchisor typically is going to require that the franchisee include in its lease that it has a right to transfer its lease to the franchisor in the event that the franchise agreement terminates. That's often included in the lease rider or lease addendum that gets attached to the lease agreement. But in some cases, I've seen it where it's actually just noted as a required provision, and it's on the tenant to ensure it gets put into the main body of the lease agreement. In that case, it is important to examine your transfer provisions in your lease to ensure that you do have that unilateral right to transfer to the franchisor just by providing notice to the landlord that that is occurring. In some cases, there will also be limitations where the franchisor does not want to have to pay any transfer fees for that. So you may also have to specifically include that transfer is done without any type of assignment fees or any penalties imposed on the landlord. There may even be specific to the landlord certain exclusions for liabilities for past defaults. For example, if the franchisee tenant is behind on rent, you may be required to put in the lease that the franchisor can assume the lease, but isn't required to pay your past due rent or get you current on that the landlord can still only look to you as a tenant to reimburse that. That is a pretty significant provision and a limitation on the landlord's rights that isn't typical in situations outside of a franchise, while it is typical within a franchise system. And so you may see some pushback on that. But it is important to know whether that is in your agreement and bring that to the landlord's attention from the start so that you can start that process of negotiating that and ensure that if there are any required changes from the landlord, that the franchisor agrees to those. Other situations may involve a situation in which the tenant is looking to exit the franchise agreement. One common way is that the franchisee may want to sell its business to another franchisee of the franchise system. So in many cases, it's beneficial to include in these transfer provisions that the tenant has the right to transfer to another franchisee of the same system. Typically, the franchisees are going to have to go through the franchisor's qualifications So in some cases, the landlords are comfortable with just that broad language. In other cases, they may still need to be qualified under the landlord's requirements to qualify as a tenant. So there may be some adjustments there in terms of what level of financial strength you need to show or business experience in order to have that unilateral right to transfer without needing the landlord's approval or without the landlord being able to deny its approval. Another situation is if the tenant needs to sell its business, but it isn't to another franchisee. They just want to sell their business to exit. Either the franchise agreement is terminating by mutual agreement or they're at the end of their term. At that point, that would be someone that is purchasing either substantially all the assets of the tenant or the ownership interest, whether that's membership interest or stocks in the tenant entity. In that case, usually there are more restrictions that landlords will want to see on those types of tenants or those types of transfers. They may want to specify that they have to meet the landlord's qualifications, or they may even list what those qualifications are. Typically, I prefer to list those qualifications in the agreements so that you know what they are at the time. So you know how to vet potential buyers and you're not wasting your time negotiating and trying to make a sale that the landlord's not going to approve. And so those are ways that the tenant can ensure, one, that it's complying with the lease to make sure that it has the right to transfer to the franchisor, but also to protect itself. As if the franchisee is having to exit the franchise agreement, one of the biggest liabilities that the tenant faces or the franchisee faces is the liability under the lease. And so anything that you can do within the lease agreement to minimize those financial burdens is beneficial, because it gives you more flexibility to exit the franchise agreement without incurring significant monetary damages. On a similar note, most lease agreements are also going to require a personal guarantee, especially for franchises that are your very first franchise, your very first business. In many cases, even if you operate under a business entity, there will be some requirement to put a person behind that to guarantee that the payments are going to be made. There are a few ways that you can, as a tenant, can limit your damages here. And again, this goes back to your ability to have flexibility to leave the franchise agreement. In many cases, a franchisor is not going to, even if there's fraud or reasons why the franchisee is terminating the franchise agreement, or that the parties are mutually agreeing to terminate, there may not be a payout going to the franchisee that helps cover any damages under the lease. And so if there's not a solution to protect the tenant and their finances, then that can put the parties at a position where negotiating a solution and an exit from the franchise agreement can be very difficult, because the franchisor may not have the funds to pay that out or to take over the lease, and the franchisee may not have the funds or the desire to pay out the remainder of this lease. And so that can often be the obstacle that the parties are trying to overcome if they're trying to work out an exit. And so working with the personal guarantee and trying to give some flexibility there can help with protecting the tenant franchisee and ensuring that they have that flexibility in the future. One way that you may be able to do this is to negotiate a burn-off. A burn-off is essentially a time limit on how long the guarantee is effective. So if the lease agreement's 10 years, a landlord may say, as long as you've been in compliance for the first 3 years, or if you're in compliance at the time that 3 years expires, we'll let the guarantee lapse, and now it's just on the tenant entity. So if you terminate at any point past that, they can only pursue the tenant entity for damages. They can't go to the individual that signed the personal guarantee. In some cases, there's also what's called a rolling guarantee, and that's where the guarantee terminates after a certain period or is limited after a certain period. So you may say that after 3 years or whatever period it may be, that at that point it becomes a rolling 6-month, 12-month guarantee, which means that you're only liable for the damages for the 6 months or 12 months. So instead of being liable for the rent for the remainder of the term, you're only liable for the rent for that 6-month, 12-month period, whatever it may be. So there's a cap on the monetary component. And so that's also another option. The ability to receive these and the duration of the burn-offs and whether there's a rolling component at the end is completely dependent on the landlord. In some cases, landlords are pretty flexible on this, and others, they want to ensure that that they're getting what they're bargaining for. They're paying out a lot of costs going into it for the tenant improvement allowances, for the broker's fees, and so they want to ensure that they're getting they have someone to pursue if the agreement terminates. And so you may not have much flexibility here, but this is something that is typically best to discuss at the LOI phase prior to getting into the weeds of the lease agreement. Another option is to offer a corporate guarantee. This is really only an option if you're operating multiple businesses. For example, if you're a multi-unit operator and you have multiple locations, you can have one location serve as a guarantee as opposed to you individually. That will depend on the financial condition of the other businesses, but it could be an option if that is something that's available based on what other businesses you own. Another component is the requirement to de-identify at the end of the lease. Many lease agreements will say that the landlord owns all the improvements that were made to the property, and when the tenant leaves, they have to leave all of that property there. Improvements, not all of the furnishings and things that can be moved, but for those improvements, the tenant may be required to leave those. Or in some cases, the landlord may have the right to require the tenant to remove those upon termination. Some of those items, depending on what they are, may have the franchisor's intellectual property on it. For example, their trademarks, their trade names. It may be part of the franchisor's trade dress, and so they may not want to leave that there for another tenant to come in and use. And so this provision that is a very common provision to see in leases that requires the landlord or the tenant to leave the improvements if the landlord requires, may need to be modified to allow for anything that constitutes the franchisor's trade dress to be removed if it's required by the franchisor. And that's something that if the landlord needs more flexibility there, you may be able to add in a requirement that the franchisor has to identify what those things are prior to them being installed on the property. As we've kind of alluded to throughout through this seminar, the franchisors often require franchisees to include a lease rider or lease addendum in their lease agreements. This is essentially an amendment that modifies certain portions of the lease in order to give the franchisor certain rights. Typically, this will give the franchisor the right to assume the lease if the franchisee defaults either on the franchise agreement or the lease agreement. In many cases, if the franchisor assumes the lease, they're not required to pay any back rent to the landlord, and so that can be a sticking provision, as we discussed before. It may also provide that the landlord has to give the franchisor a certain amount of time to cure the franchisee's other defaults. It may have to provide notice and opportunity to cure beyond what the tenant gets. So if the tenant has 10 days to cure a failure to repair something, this amendment may say that the franchisor has 20 days after the tenant's period has expired in order to jump in and fix that. Again, this can be a sticking point for landlords as well, because it effectively lengthens out the amount of time that these breaches are going uncured. It may also allow the franchisor to then transfer the lease to one of its franchisees. And essentially what this does is it allows the franchisor to come in and preserve the franchise location, especially if it's a successful one, and sell it to another franchisee so that they don't lose that store. It doesn't close just because of whatever breach that happened with this particular tenant. And so there may be that second component of the transfer provision that allows the franchisor to do It may also allow the franchisor to enter onto the property and remove its trade dress and signage. The reason for this is that franchisors typically do not want people to see a vacant or abandoned building with their names on it. It makes it look like the business is going under or isn't doing as well. And so you don't want to be able to identify these closed down places with their name. And so they will like to go in and remove those if the franchisee fails to do so. And so it typically allows them the right to enter the property to do that. So those are usually the most common things you see in these lease agreements or these lease riders. Because these do have some pretty strong provisions that protect the franchisor, it is important to make sure that the landlord's aware of this agreement from the very start. Many brokers and agents will put this as an attachment on their LOI so that the landlord is made aware of it from the start. And it's important to negotiate these alongside the lease so that the franchisor has time to review. It is typical that franchisors do see landlords make red lines to them. And in that case, it's a case-by-case basis on whether or not the franchisor will approve the changes and if the landlord and franchisor can come to an agreement on those. Another provision, I've alluded to this a little bit with the relocation provisions, are casualty losses. Franchise agreements typically will allow a franchisee to relocate if there is a casualty loss to the franchise business, such as fire, tornado, something that damages the premises. In those cases, there may be restrictions on how much time the franchisee has to reopen. And so those should be looked at in comparison to what the lease says in terms of the tenant's rights when a casualty event happens. In some cases, the landlord does not give the tenant a right to terminate, and the tenant does not have any protections in terms of how long those repairs can take. And so if the franchise agreement requires them to reopen in 6 months or some other period of time, but their lease agreement doesn't have that restriction, then they could end up in a situation where they're now in breach of their franchise agreement. And if the franchisor isn't flexible with that, the franchise agreement could terminate before the tenant's able to reopen in that location. And so mirroring those two provisions is very important to ensure that the landlord is required to deliver the property to the tenant so that they can comply with their franchise agreement, or at the very least that they have a right to terminate the lease and look for a new property if that's going to be needed, if the time frame is just going to be too long for repairs. Typically what I recommend is having the landlord provide the tenant with a notice shortly after the casualty event that estimates how long it's going to take for those repairs to occur. And if the repairs are going to take longer than a certain period of time, that it gives the tenant a right to terminate at that point so that they have time to go and find that new location. That's also, I typically like coupling that with the right to terminate if repairs actually take longer. So even if it's predicted to be within that time frame, but there are certain delays and it takes longer, that would also trigger a right to terminate. In addition to those, there are certain provisions that I just like to point out as something that tenants should be aware of, but aren't necessarily specific to franchisees, but should still be looked at whenever you're negotiating these leases. One is contingency clauses. The franchisee or tenant may want rights to terminate the lease agreement if certain things aren't able to occur. For example, if the tenant isn't able to obtain their permits to operate for their permitted use in the space, they may want a right to terminate the lease so that they can move elsewhere so that they're not bound to pay the rents there when they're not able to operate for the reasons or for the purposes that are required under the franchise agreement. Depending on what industry the franchisee's in, if they're in a highly regulated industry or something that's kind of new on the edge of new laws, for example, things like CBD, there may be a desire to have a contingency clause that allows them to terminate the lease if their use becomes illegal or no longer permitted at that location. Another provision are exclusive use clauses. We've talked about these in the sense of other tenants' exclusive uses being able to restrict the tenant and what they're able to do. But in many cases, tenants want to include exclusive uses of their own to protect their ability to generate a profit at that location. So what an exclusive use would look like is that the landlord would agree to not enter into another lease on the property that allowed another tenant to sell whatever your primary products are. And then also include certain conditions or consequences that would occur if those exclusive uses are violated. Typically, that looks like a rent abatement with the right to terminate after a certain period of time if that violation isn't cured. Another thing that's important to consider is our force majeure clauses. These are the clauses that permit delays in tenant completing certain actions if there are certain things beyond their control that happen. For example, if you're not able to open because you can't get your permits in time, you submitted everything, you're diligently pursuing them, but something's going on in your local government that's keeping those from coming. If there are supply shortages, labor shortages, and so those are particularly important to look at as well. Another provision that I always like to point out is the limitation on the landlord's liability. These are becoming very common provisions where there may be a provision that says that if the tenant has any kind of judgment against the landlord or any damages, that they can only collect on the under the landlord's interest in the property on the sale of the property, meaning that you won't be able to collect those damages unless the landlord decides to sell its interest in the property. And then you're limited to whatever that purchase price is. And so those can be very limiting and really a deterrent from the tenant ever asserting its rights, especially if it means going to court. And so that's something that I try to get removed if possible, or at least include amounts received as rent so that the income coming into the landlord is also included in what you can collect against. So with that, that is our presentation for today. Thank you all for joining, whether you joined live or looking at this video later. I greatly appreciate you spending the time to learn about leasing for franchisees with me. Again, if you have any suggestions on topics you want to hear about in the future, please feel free to comment on the video or send those over to us. We'd be happy to look at doing those in the future. Have a great day.